City of Tarpon Springs versus Michael Vaporis. I hope I got that right. Good.
Good afternoon, Your Honors. May it please this honorable court, my name is Lamar Oxford. I'm here on behalf of the Florida League of Cities and one of its insured members, the City of Tarpon Springs. This court is well aware that this relatively simple and straightforward appeal involves the application of the so-called firefighter's presumption in a heart disease case involving a firefighter. I would respectfully submit that this is an issue of great importance to the League of Cities and its members, thus an issue of great public importance. There are thousands of firefighters of baby boomer age who are or will be submitting their claims for heart disease as a workers' compensation claim.
Well, Mr. Oxford, you know, we do all the workers' compensation appeals in the state, unfortunately. Yes, and we're already seeing lots of these, and we commiserate with you, but it seems to me you ought to be complaining to the legislature for adopting this statute.
Well,
and you've probably already tried that.
I haven't in particular. I'm certain the League lobbyists are discussing that, as are League members discussing it with their local delegations all over the state. But, thankfully, this court has held 20 years ago that the statute is clear and unambiguous, and thus it must be strictly construed and strictly applied. We think the facts of this case call out for this court, this honorable panel, to write an opinion to clarify to the judges of compensation claims how, again, exactly the statutory presumption should apply.
Doesn't this case turn on whether the claimant's medical examination was sufficient to satisfy the requirements of the statute?
That is one of the...
Isn't that the essential argument in this case?
No, sir. I would, Judge Webster, I'd respectfully submit that's our secondary argument for reversal, although we will never, ever give it up. If you apply this statute strictly, this gentleman's physical exam was performed after he entered service as a firefighter.
But the statute doesn't say before entering service. It says upon entering service.
That is absolutely.
And to me that means at essentially the same time as you enter service. And this was completed within, what, a month? Started before, finished after.
Fair argument. In Sledge, this court held that the statute requires a pre-employment physical. So that's the linchpin of our argument on the strict construction.
Well, you're not suggesting that that language in Sledge was a holding on this issue.
And that's not a quote from the statute. The statute says upon entering service as a firefighter. So I would fairly admit that the debate could be made on both sides of that particular argument, and that's why that is our secondary argument. Our primary argument jumps off the page. If the judge correctly applied the statutory presumption, which we submit is not true, but assuming arguendo it was correctly applied, then the employer has the right and the burden to come in and rebut the presumption by proving that the heart disease or heart attack, both of which exist in this case, was caused by, quote, non-occupational factors, end quote.
But isn't that sort of, the beauty is in the eye of the beholder? The JCC didn't think that evidence prevailed over the presumption. So isn't that a balancing methodology that we have to follow, and this is an abuse of discretion?
No, sir, it's not a, well, if you want to balance it, I want to make it real clear. We're not here on a weight of the evidence argument. And yes, we are here on an abuse of discretion because, with respect, the JCC here substituted her expert medical opinion for that of the only doctor who testified.
Well, is she bound to follow what a doctor says? Can't she disbelieve the doctor?
On an opinion, Your Honor, in an area on what caused a heart attack, in the face of overwhelming proof in support of this doctor that this gentleman was borderline hypertensive when he started as a fireman. He was 5'10" and 240 pounds. There was no question he was borderline obese. There was a significant history of heart disease and heart attacks in his family. His mother had died of a heart attack. He had high cholesterol.
I think he smoked too, didn't
he? And he smoked for 20 years. A minimum of 10 cigarettes a day. He said a half pack. No wonder the doctor rejected the idea that anything related to his activities as a fireman, 24 on, 48 off, caused this heart attack. The doctor even noted that while the incident on his second job at Publix, when he's stacking and stocking cases of bottled water and soda, while that no doubt instigated the heart attack, and there was no question that nothing he did as a fireman actually directly caused the heart attack, the doctor says it's all those significant risk factors that this gentleman had, unrelated to being a fireman, that actually caused his heart disease and his heart attack. I don't think that this honorable court should sanction judges wholly rejecting the only expert testimony from a board-certified physician as to the cause of this gentleman's heart attack and substituting her own by simply saying, I don't believe it.
Was he a probationary employee when he started?
Yes, sir.
Well, now, if your interpretation of the law is correct, what would stop a fire department from simply having a policy of hiring probationary employees and then giving them the physicals after they start working?
Nothing,
it could completely defeat the statutory presumption forever by doing that, couldn't it? If your position is right.
Well, now, there's no evidence here that any Machiavellian person at the fire department back in 1986 was trying to set
No, but if we
anybody up.
write an opinion that says what you want to, it won't take Machiavellian, it won't take any Machiavellian intent. People will simply say, the first DCA has said, well, your physical wasn't complete, so here's an idea for a new policy. Don't give any probationary employees a physical until after they start.
Like I said to Judge Webster, that is a difficult area for us. If you strictly apply the statute, then the presumption wasn't met here. The IRC said in 78, like this statute or not, the legislature wrote it the way they did, and it is not for us to change it or modify it by judicial interpretation, but to go to the legislature if anyone thinks there's an inequitable result. And this court parroted that language, I think, in Sledge or Cumbie about potentially inequitable results, because a person becoming a fireman may not know that he needs a clean physical before he becomes a fireman to get the benefit of the presumption 20 to 30 years down the road. But the legislature often writes laws that sometimes lead to inequitable results. But I'm here today primarily to argue that you can't let the judges wholly ignore the only medical evidence in the entire case as to the cause of heart disease or heart attack in a fireman and substitute their own judgment. This doctor said he's never read and he's been doing this for 25 or 30 years, he's never read a study that says a fireman is at greater risk for heart disease than an ordinary person.
But didn't you lose that argument? The doctor lost that argument in the legislature. Because the legislature sort of said, you know, that's the cause of it. And it doesn't necessarily have to be based on reality. They say it. That's the way it is. You have to live with it till you get it changed, as Judge Webster implied earlier.
That's a very good point. And if there was a doctor in this case, claimant could have gone to their own physician. If there was a doctor who testified the firefighting work caused or seriously contributed to this heart disease, then we probably wouldn't be up on appeal, or I would be sitting here licking my wounds, basically. But here you got a judge who completely ignored the only expert testimony. Now surely that can't be allowed. It's a simple appeal, but it's an important one. If the claimants can bring in evidence to overcome the employer's attempt to rebut the presumption, then the employer could and should lose under the statute. We question whether the statute was properly applied here. In fact, this gentleman's blood pressure at the time he started was 124/86. Under today's standards, if the diastolic is higher than 80, you're borderline hypertensive, and that's before he started.
Well, but
Which
there's
is
a
another
difference
requirement.
There's a difference between borderline hypertensive and hypertensive.
Well, perhaps if it was 80, he'd be borderline hypertensive, but it was 86.
Well, I happen to know this because I run about the same level normally, and my doctor says that's borderline.
Well, I'm not going to, I'm on Lipitor. We're all, there's a bunch of us baby boomers out here, and there's a lot of them in fire departments who are looking to retire on workers' comp. God love them.
I think you still have to get over 90 before it's considered hypertensive.
The testimony in this case, Dr. Ahmed, that was discussed, and he talked about 80 is the new standard. 90 may have been the
But isn't
standard.
that irrelevant to what we're talking
Yes,
about?
sir.
You didn't have to hire the man if it had been 80/60 or 200/110. You hired him, so you're stuck with the presumption, aren't you?
No, we're not stuck with the presumption.
Well, I mean, it's on the books. Maybe that's a bad word.
We're stuck with the presumption in general. In this case, we don't think it should apply, but much more importantly, this is a case about the sole expert medical evidence in a question that's clearly medical. Lay people can't come in and tell you what causes heart disease in a particular person as compared to somebody who studies it, analyzes it, tests for it. And that's really the linchpin of this appeal, and we would respectfully request reversal and an opinion. Thank you.
Thank you. May it please the court, Jason Fox from the law offices of Carlson and Meisner, and with me, Josh Stewart, on behalf of Mr. Vaporis. Essentially, we're here.
Mr. Fox, is the section 112.18 presumption conclusive or rebuttable?
I believe that per Caldwell, it may be, it is writing Caldwell at page 440, it is not overcome until the trier of fact believes that the presumed fact has been overcome by whatever degree of persuasion is required. And it goes on to say that this may be, in this case, by clear and convincing evidence.
So conclusive or rebuttable?
I believe it would be rebuttable by clear and convincing evidence.
Was there any evidence presented from any expert in this case to suggest that your client's hypertension was caused by anything other than factors unrelated to his job as a firefighter?
Well, Judge, the doctor that we had seen was an IME doctor.
He was
from
your
list.
IME doctor, wasn't he?
It was our IME paid for by the carrier from their list. That's the only doctor here.
Okay, so
The
we
problem-
got one doctor's testimony.
Well, the problem is with that doctor.
What did he say?
Well, that doctor is a non-practicing cardiologist. He's a board-certified internist. We could not find on an IME list a cardiologist.
Haven't we
And he
held,
doesn't believe in the statute.
haven't we held many, many, many times that for injuries that are non-readily observable, such as heart attacks or hypertension, you have to have expert medical testimony?
Well, I believe that the expert testimony was sufficient to qualify the 4-point test, which is what got us the presumption. And the courts have previously stated that the purpose of the statute and the presumption, it embodies the social policy that recognizes that firefighters are subject to this
Okay,
cause.
so if I understand was it Judge Hafner?
Correct.
If I understand her ruling, it was that the IME doctor, who was the only expert who testified, even though he testified this had nothing to do with the job of a firefighter, that was insufficient to overcome the presumption. And the only other medical evidence in the case, which was the evidence of your client's treating physician, and that came in, I guess, as fact evidence, not as expert evidence, was to the same effect, wasn't it?
That he had had a heart attack, that's correct. But again, I think it needs to go back to this doctor, which, again, he agreed that at the time of the individual evaluation, there were no symptoms, and now he had the symptoms. That's essentially what we were looking for from this doctor.
Well, that gets you the presumption.
Right.
But you've told us that's rebuttable.
Correct. And the doctor then, when asked in a question upon which we did object to, because it was unsubstantiated and did put facts that were not in evidence to this doctor. So this question that's being raised by the appellant, I believe, was objected to, and it needs to be looked at.
Did you cross appeal that ruling?
No, we did not. But essentially, the doctor was asked if he felt these different risk factors could be a part, and he said yes, but that is in direct contrast to what the statutes have said, and I believe that based on that fact, that the judge had more than enough basis to not follow what the doctor had said in that opinion, and I don't think that even that opinion would rise to the clear and convincing evidence to overcome this, which is what would be required. But I believe that the doctor's opinion, by simply stating he does not believe in the Florida firefighter statute, that he does not believe that firefighters have a higher stress level, which has been long acknowledged by this court and by the legislature, which was the purpose of the statute, that essentially by him ignoring these factors, the judge had more than enough reason to look at this and say, this doctor obviously doesn't know that we have this accepted.
Is it your position that testimony from a doctor to the effect that a firefighter's family history of coronary artery disease and diabetes and the firefighter's high cholesterol and smoking were the reasons for the hypertension rather than his being a firefighter, that could never overcome the presumption?
That is, I think, a fact-sensitive situation, but I don't think that those factors could overcome it. And the reason is, part of the reason of the statute is that these firefighters are at a great risk. And in the case of Carpentieri, they explain how the extraneous risk and smoke inhalation and everything else, and how they have to have all these intense pressures put upon them. Did the legislature contemplate that when saying, well, maybe those may help cause high cholesterol, or maybe those will help cause hypertension? Well, all these stresses, and if we start looking at the stresses that may have been considered by the legislature as the purpose of protecting this statute, wouldn't we be defeating the legislative intent of this statute by saying these risk factors can now be circumvented and defeated?
Well, I certainly agree with you that we have to determine from the language the legislature used what it had in mind. But it seems to me that a fair reading of the statute reveals nothing more than that the legislature intended to change the burden, or to switch the burden of persuasion in firefighter / police / whatever else type cases, so that instead of the normal burden where the claimant has to come in and prove that the injury is work-related, now the claimant begins with a presumption that it is, and the employer has to come in and prove that it's not. Isn't that all the legislature appears to have intended here?
Well, I believe that they created that presumption, but then now we have cases like the Supreme Court in Caldwell where they say it was clear in recognition of the special hazards and stresses placed upon firefighters during their career. And then when we take that into account, thinking about the mindset and frame of the legislature and how Caldwell, the Supreme Court, interprets what they believe they were thinking, we now look at how this honorable court has worked into tests. And I think we can look at the reverse Victor Wine type defense, where I believe it was indicated that you need, in addition to the clear and convincing you need to have a specific incident. It has not been determined previously that risk factors can do it. It has been said consistently that there has to be a specific incident that overcomes this, and more so than even like cases where the statute has been upheld, where firefighters have been off work pushing wheelbarrows and doing other types of activity, that still they were entitled to that presumption. They did not lose the presumption and maintained it because that, I believe that specific incident did not cause it.
Have you found any case from this court that upholds an award to a firefighter / policeman / whatever in a situation where there's absolutely no evidence that the condition was caused by the job?
That the condition was caused.
Where all of the evidence, whatever evidence there is, all of it is to the effect that it was not caused by the job.
I believe the only the evidence that the doctor, again, who's just an internist, testifies to the risk factors. I believe the many cases that we have at hand, the firefighters never come in and say, I had a strenuous activity on day X.
But
I watched a burning body
in every case I know about involving a firefighter or a policeman, either their IME or their treating physician testifies that he or she believes that this was caused in response to the employer's evidence to the contrary. Either the claimant's IME or their treating physician comes in and says, I believe this was caused by his or her job as a firefighter.
I don't believe that is a necessity with the presumption, but again, I don't believe that every case does contain that. I believe that there are cases that I can't point to it specifically, but that it just present the presumption, and at that point allow the defense to attempt to overcome that with the clear, convincing evidence, and to show, or basically the burden shifts when we have done what we have done here and satisfy the four-pronged test. The burden shifts to basically the appellant or the employer that they need to provide proof of a specific hazard or non-occupational hazard as the cause. That is the test that is there in the Victor Wine or reverse Victor Wine type documentation and case law. So I don't think that is a requirement. But to go further, I agree that this case is very important, going back to what Your Honors had mentioned about the first point, and that is the definition of upon entering into service, that the distinction needs to be drawn between the pre-employment versus the actual statutory language, and we promote that this needs to be maintained with strict construction, that it's upon entering into service. And as Your Honors had said earlier, it means essentially at the same time, which could be within a month, within a reasonable degree of time. We believe that it can be circumvented and defeat the statute if we did use that pre-employment physical and basically said, okay, you're hired today, go get your physical tomorrow. That statute would never take any effect.
Or we can't get an appointment for you until next month with our company doctor, but we want you to start today.
Right, and in this situation, my client had an appointment 15 days later set by the employer, and essentially the physical began beforehand because he had his EKG and his x-rays and blood and urine taken prior to when he began employment. So we feel that the upon entering into service is absolutely met, but it also can be separated from the Sledge and other case law, which Sledge was 6 years before a physical was done, and this was a statute of limitations argument in that case. It was not regarding the firefighter presumption, and it was simply mentioned, I believe, as an ancillary note. And also, Cumbie, another case that is mentioned, there's a 2-year gap firefighter begins working. 2 years later, he goes and has his physical. That, again, refers back to Sledge, which I believe is where that pre-employment language began, and I would submit the argument that it should stick strictly with the statutory language of upon entering into service. Now, essentially, the doctor also felt that the claimant had passed the physical exam upon entering into the service. Thus, he was entitled to all those, to the benefit. And again, I would just like to focus that there is not a specific hazard or non-occupational cause. These risk factors, if we're entitled to, if the defense is entitled to raise risk factors, I believe everyone, all baby boomers, as he mentioned, as we get older, are going to have additional risk factors. I don't believe that the risk factors were contemplated, and if we were to allow risk factors as a defense, which they are not this specific hazard, you would be defeating the statute. If the legislature wants to change that language, I believe they would have to go ahead and change the statute. But then I think there are other aspects of the statute that would need to be changed as well. But essentially, I don't think it would be allowable, it would be wise to allow that, because you would be penalizing lifelong firefighters. The longer they stay a firefighter, they would gain these risk factors, and if they go ahead and have an incident towards the end of their career and they try to submit under the statute, they would be denied based on risk factors. I don't think that this argument can be allowed to stand. Thank you.
I'll be brief and try to get the focus back on the key argument here. This is not the time to attack the credibility of the only doctor who testified here. This doctor testified that he was a board-certified internist who practiced non-invasive cardiology for 25 years. Not that he wasn't practicing. All he did was admit that he doesn't cut chest open and operate on hearts.
Mr. Oxford, can you give me a case where it stands for the proposition that a trier of the fact, whether it be a jury or a JCC or a trial court, doesn't have the right or the power to reject expert testimony?
Not off the top of my head, Your Honor, but I would respectfully submit that in a case like that, which would have to be an exception to the general rule, there would have to be clear-cut evidence that the doctor's opinions were either outlandish or he was a quack or a fraud, none of which is here.
Well, now, the judge of compensation claims seemed to think that the way to rebut the presumption was not with testimony that these risk factors came about naturally through, let's say, high blood pressure, high cholesterol, or whatever. But she says here in her order that you presented no evidence that the non-occupationally related risks. Well, she says that your evidence on this point falls far short, that's what she says, of establishing that some other specific hazard or non-occupational hazard was the cause of the claimant's disease. And what she was referring there to was your argument that, well, he was working at Publix picking up boxes and that must have caused it. And she said, no, your evidence falls short of showing that some other hazard caused this. So I guess my question is this, and I need to study this a little bit more. Is that how you rebut the presumption, or can you rebut it with plain old medical evidence saying that, well, he was fat and he had high cholesterol?
And B and C and D and E. Your Honor, that's the only way to rebut it. Plain old medical evidence is key to litigation.
But there's nothing about this statute that requires a rebuttal by showing that some other specific hazard or non-occupational hazard, to use the language in the JCC's order.
How else but show it through the testimony of an expert picked by the claimant who takes the entire history into account in the course of doing an examination of the man's heart. That's the only way to prove it. We can't bring in Tom, Dick, and Harry, or even the captain of the fire department, to come in and say, we don't think his work as a fireman caused it. We have to bring in medical testimony, and more importantly, they can bring in theirs. This was their guy. This was the only doctor who testified. And what I forgot to tell you is that to the extent that the factual testimony and history taken by the treating cardiologist, Dr. Stein, in this case, was admitted, he talked about the fact that this gentleman not only had a serious family history and high cholesterol and the smoking, but he also talked about these risk factors being obvious. The mother's side of the family, significant heart disease history, hypertension. He has not read any literature. This isn't an opinion. This is factual testimony from Dr. Stein. He has not read any literature that supports the proposition that firefighters suffer cardiac problems more than other members of the public. He thinks the claimant was at a significant risk of a heart attack because of the non-employment related risk factors, and he even talked about the problems with Viagra because that came up with this claimant too. But the bottom line, again, is that there is no carte blanche given by this statute. It gives them the presumption. It shifts the burden of proof. We proved it. They could have disproved it, and then the JCC could have weighed the medical evidence and made it a much more difficult appeal. They took their chances with this doctor, and his testimony was directly on point. This 51-year-old gentleman's heart disease and heart attack was not caused by him being a fireman, and a layperson can't, or nor a judge can say otherwise. Thanks very much for hearing us out.
All right.